हेलो हेलो।
हेलो हेलो।
Good afternoon to one and all present here. On behalf of Rashtrasan Tukaroji Maharaj Nagpur University's Dr. Babasaheb Ambedkar School of Law, I, Dhanashree Mishra, warmly welcome you to the grand finale of 23rd Justa Causa National Moot Court Competition 2026. As we gather here, we are reminded with the words, "The law is reason free from passion." In this courtroom, the reason will drive our arguments and passion will fuel our pursuit of justice. A very warm welcome to esteemed judges, participants, and everyone joining us today. You may kindly take your seats. To deliver the welcome address, may I now invite the teacher coordinator of National Moot Court Competition, Vidya Nayak ma'am.
Good afternoon to the esteemed judges, Justice Srimati Mukulika Javalkar Madam, Justice Shri Prafulla Kubalkar Sir, our Director, respected Pravi Shankar Moore Sir, faculty members, participants and dear students. It is with immense pride and honor that I extend a very warm welcome to our esteemed judges, whose presence today elevates the significance of this occasion. We are truly privileged to have Justice Javalkar Madam and Justice Kubalkar Sir amongst us, whose wisdom, experience and commitment to justice continue to inspire legal professionals. Today marks the culmination of days of research, compiling arguments and intellectual perseverance. As we begin the final round of the 23rd Justa Causa, the National Moot Court Competition, let us witness the best of advocacy, dedication, and legal acumen come together. To our finalists, a heartiest congratulations. Your journey to this stage is a testament to your hard work. Standing here today, you represent not only your institutions, but the future of legal fraternity. As we proceed, let us remember that moot court competitions are not merely about winning, but about learning, evolving, and embracing the spirit of healthy competition. So, with great enthusiasm and anticipation, we look forward to an engaging and thought-provoking competition. Thank you, and once again, a warm welcome to all. With this, we begin the competition. Thank you.
It is now my honor to introduce the judge from the panel, Honorable Justice Srimati Mukulika Javalkar ma'am. Ma'am has completed her LLB in the First Division and LLM in Constitutional and Administrative Law, along with BCom and MCom. She enrolled as an advocate in 1989 and actively contributed to the legal fraternity through various roles in the High Court Bar Association and Vidarbha Lady Lawyers Association. Directly appointed as district judge in 2008, she served across multiple key positions, including family court judge, joint charity commissioner, and principal district and session judge in various districts. She also holds the distinction of being the first chief lady judge of the Small Causes Court, Mumbai. She was part of an international academic delegation to Australia in 2009 and was elevated as an additional judge of Bombay High Court. It is an honor to have you here, ma'am. Celebrating our tradition of honoring esteemed judges, we now proceed to a moment of special recognition. We request our director, Dr. Ravi Shankar Moore sir, to felicitate Honorable Srimati Mukulika Javalkar ma'am, judge at Bombay High Court, with a token of appreciation. Thank you so much, sir. It is an honor to now introduce our next judge from the panel, Honorable Justice Shri Praful Kubharkar, sir. Sir has graduated in law from Dr. Babasaheb Ambedkar College of Law, Nagpur University in 1997, while simultaneously completing his BCom. He thereafter obtained his LLM in commercial laws in 2008. A meritorious student, he was awarded silver, gold, and several gold and silver medals, including the prestigious Silver Jubilee Prize of the Bar Council of Maharashtra and Goa for securing first rank in the LLB course. He was enrolled as an advocate in July 1997. He started independent practice in 2008 and handled diverse matters in civil, criminal, constitutional, and service laws, including arbitration. With around 27 years of experience, he has appeared before the High Court, District Court, tribunals, and the Supreme Court. He has also served as an amicus curiae in select matters and was Secretary of the High Court Bar Association, Nagpur from 2017 to 2022. He was elevated as an additional judge of Bombay High Court on 25th October 2024. It is an honor to have you here, sir. I request Dr. Ravi Shankar Moore, sir, to felicitate Honorable Justice Shri Praful Kubharkar, sir, Judge at Bombay High Court, with a token of gratitude and appreciation. Thank you so much, sir. It is now time for what we all have been waiting for. We request all the participating teams to please begin the rounds, and we wish all the participants all the best.
Your Lordship. Your Lordship, the Council seeks permission to approach them. The Council seeks permission to address the bench collectively as Your Lordships. Am I audible, Your Lordships? Hello? Hello? Am I audible, Your Lordships? Your Lordships, with your permission, I shall begin with the statement of facts. I shall take around 1 minute to explain the statement of facts to you. May I begin? May I begin? Your Lordships, the Republic of Vandhara is a nation with 300 million people, and it stands as one of the best examples of democracy. Vandhara is known for its various cultures and political disclosures, Your Lordships. The Republic of Vandhara's journey to becoming a digital nation is noteworthy, Your Lordships. The nation encompasses of 280 million internet users, a thriving startup economy, world-class IT industry, and an aspirational digital Vandhara mission. However, Your Lordships, with technological progress arose complex challenges. During the year 2024, Vandhara witnessed incidents of mass violence, allegedly triggered by social media posts. There were documented cases of foreign interference in state elections, misinformation campaigns, and terrorist organizations spreading their ideologies through social media platforms. Your Lordships, the sensitive situation in the state of Vandhara gave birth to the Prevention of Online Hate Speech Bill, which amongst protests was enacted by the Parliament, even as 48% of the Parliament's members stood outside in opposition to the Act. The aftermath of the enforcement of the Act is the basis for this present petition, Your Lordships. Firstly, Your Lordships, a university professor was taken into custody for his social media post analyzing historical religious conflicts, Your Lordships. Secondly, thereafter, Ms. Neeti Srivastav, who is a tech entrepreneur, was asked to share her proprietary algorithms with government-approved bodies. Aggrieved by the impacts and the alleged violations of fundamental rights, the Digital Rights Foundation, alongside Mr. Avinash Venkatraman and Ms. Neeti Srivastav, along with the opposition parliamentarians, have filed this petition before the Supreme Court, Your Lordships. The Chief Justice of Vandhara, noting fundamental questions raised about democracy, has constituted a special bench for hearing the present matter. If Your Lordships are clear with the facts of the case, I shall move ahead with my arguments. Your Lordships, I shall be dealing with the first and the fourth issue, and my co-counsel shall be dealing with the third and the fourth issue. With your permission, may I go ahead with the first issue, Your Lordships? Your Lordships, issue number 1 deals with whether the definition under Section 3 of the Online Hate Speech Prevention Act is vague and thereby overbroad and vague, and thereby in violation of the provisions of the Constitution, Your Lordships. Your Lordships, if you may refer to Section 3 of the Act, please, which is on page number 5 of the Moot proposition. Your Lordships, are we on the same page? may I move ahead? I shall explain the provisions also for your perusal. Your Lordship, Section 3 of the Online Hate Speech Prevention Act of 2024, which is dealt under Chapter 2, deals with what is online hate speech, which basically criminalizes any online speech that promotes, spreads, provokes, or arouses religious enmity and religious sentiment, or denigrates individuals based on real or attributed characteristics. The counsel for the petitioner, Your Lordships, would like to present my contentions in a threefold manner. Firstly, that the provision does not take into consideration the likelihood or the intent to cause violence. Your Lordships, Article 19(1)(a) of the Constitution clearly sets out the premise that the fundamental right to speech, freedom of speech and expression, may be restricted only on the grounds that have been set out under Article 19, subclause 2 of this Constitution. And therefore, to go beyond these restrictions would be unconstitutional, Your Lordships. Your Lordships, Your Lordships, I would like to break down the circumstances for you to explain as to why this is a violation of the fundamental rights. Your Lordships, we have to take the case of Mr. Avinash Venkatraman, a university professor, Your Lordships, who was taken into custody without a warrant because he made a social media post that was merely analyzing historical religious conflicts and was detained for 120 days, Your Lordships. Here, Your Lordships, Mr. Venkatraman was arrested for making a mere academic disclosure, and furthermore, it was even put under the ambit of hate speech. The provisions in this case, therefore, my submission and contention would be that it does not satisfy the test of proportionality. The test of proportionality, Your Lordships, as laid down by the Supreme Court, has 4 elements, and if a measure does not satisfy these 4 elements, then it shall be declared to be unconstitutional. I shall name all the 4 elements, Your Lordships. If we are on the same page, may I? Yeah. The first one is that the measure restricting the right must have a legitimate goal. Secondly, the measure must be suitable for furthering the goal. Thirdly, the measure must be least restrictive and equally effective. Fourth, and the last measure would be that the measure should not have a disproportionate impact on the right holder. Your Lordships, now I shall be justifying the circumstances and the provisions of the Act to lay down that these do not pass the test of proportionality. Your Lordships, the first element, legitimate aim. Article 19, subclause 2 of the Constitution states that public order or incitement can be a reasonable restriction. However, Your Lordships, Section 3 criminalizes every and any statement published or otherwise which can apparently denigrate or promote hate speech, rather than actually causing a public offense in this case, and therefore it does not pursue a legitimate aim. Secondly, Your Lordships, suitable means for furthering the goal, and the measure must be least restrictive, and it should be equally effective. Your Lordships, the Act allows for the arrest and detention of persons for speech that does not even cause public disorder per se, or it does not even cause incitement of the offense, but what it does is that it creates subjective categories such as denigration. Yes, Your Lordship.
Is it your argument that only because that particular section uses the word denigrates and arouses religious sentiment, only because of use of these expressions it has become unconstitutional?
No, Your Lordships. The contention of the Council is that Section 3 in its entirety is so vague that it is creating a very wide ambit for any speech or any opinion without it even actually causing public disorder to come under the ambit of hate speech, and therefore it is subsequently it is being criminalized in that manner. By the use of these expressions, it is further stating that the use of these expressions, because it is subjective and it may not actually fall under the threshold or the actual definition of hate speech, it is creating a very wide ambit in this case.
Wide amplitude. So how does it violate Article 21?
In this case, Your Lordships, it is because there is arrest and detention of the person. without a warrant, it is taking away the liberty of the person. Yeah.
All right.
If I may go ahead with the further proportionality.
Yes.
test. Yes. I'll just conclude the second point and as to why it is least restrictive or not. So basically the act allows for the arrest and detention of persons for speech that does not even cause public disorder per se, or it does not even cause incitement of the offense, but it rather creates subjective categories such as denigration, arousal of sentiments, which by subjective meanings, which gives rise to subjective meanings, and therefore it gives rise to various interpretations which may differ from person to person. I shall move ahead with the third and the last set, which is even the
What
more
about, before you move on to the next argument, what about the reasonable restrictions?
Yes, Your Lordships, I shall explain that through the next course, if I may. Just a second.
No, you want to move to the next fourth issue.
No, my next leg of the argument, which deals with reasonable restrictions itself.
All right.
To answer your question also, Your Lordship, I would like you to refer to the case of Superintendent Central Prison Ram Manohar Lohiya's case, where the court had stated that the restrictions on speech in the interest of public order must satisfy the test of proximity, requiring a direct and immediate nexus between the expression and the anticipated order. The impugned provision is restricting a significant fundamental right, which is far greater than any speculative or apparent possibility of threat in this case. To even answer your question, Your Lordships, because Article 19(2) talks about the threat to sovereignty, integrity, and public order per se, in this case, this is causing an apprehension or a speculation that a hate speech may cause that public disorder. So what the court in this case had said, that any speculation or any apparent possibility of threat does not come under the ambit of it. May I move ahead with the second leg of my argument, which basically talks that Section 3 of the Act is vague and therefore void for being violative.
You want to move to issue number 4?
No, my second leg of the argument itself.
Second leg of the argument. Yes, go ahead.
Yes. So, Your Lordship, Section 3 of the Act uses the words such as arouses religious enmity and religious sentiment. Your Lordship, the application of these expressions becomes subjective because its interpretation again may differ from person to person. So, the provision in this case is widening the ambit to such an extent that even a genuine comparison of offense, if we take the example of Mr. Avinash Venkataraman, even a genuine comparison, if it is not liked by anybody else, or if that person thinks that this might be offensive or it might come under hate speech, it will bring it under the ambit of hate speech. The Council would like to refer to the case of MP versus Baldio Prasad, where the Supreme Court had struck down the provision criminalizing goondas because the expression had lacked definitional clarity. The court had held that vague laws are unconstitutional as they have excessive discretion to enforcement authorities. My last leg and the last point of my argument also, Your Lordship, is that a vague law fails two constitutional requirements, Your Lordships. Firstly, it does not give fair notice to the citizens, and secondly, it confers uncanalized discretion on authorities. The terms used in Section 3 are elastic and subjective in nature, and they can be molded in any manner to fit into the definition of hate speech. Therefore, such ambiguity, unreasonable restrictions on the freedom of speech and expression will be void for vagueness. May I move ahead with the fourth issue, Your Lordship?
You just explained how it is violative of Article 14.
Lordship?
You have mentioned it is violative of Article 14 as well as 21.
Certainly. Your
How it is violative of Article 14?
Your Lordships, because in this case we are contending that the act is arbitrary in nature and it is giving arbitrary powers to arrest and detain any person also, which is again very unreasonable. And because of this arbitrariness, it will be violative of Article 14.
All right.
Yes. If Your Lordships are satisfied with the first issue, I shall move ahead with the fourth issue.
What about the test of legislative competence?
Your Lordships, in this case, if I can just get a second, I have a case law to substantiate that.
What is your submission on that?
I'm sorry.
About legislative competence to enact this law?
Your Lordships, in this case, even though the legislature had enacted this constitution with the enforcement, because it is illegal by its very nature, it shall be void, is the submission.
Legislative competence. You are challenging the provision of the act being unconstitutional.
Certainly,
Your
Your Lordships.
contention, your first ground is it is violative of fundamental rights under
Certainly.
Article 14 and 21.
Certainly, Your Lordships.
Is there any other test which has to be considered while testing constitutionality of a statute?
Your Lordships, we have referred to the case of the proportionality test, which the Supreme Court had basically laid that if it does not surpass this, then it shall be unconstitutional.
All right, go ahead.
Yes. May I move ahead with the fourth issue in that
Yes.
case, which basically deals with whether the act is unconstitutional because it does not balance between the the freedoms and the reasonable restrictions. Your Lordships, the virtues of electronic media cannot become its enemies. This was laid by Justice P.B. Sawant in the case of Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal. It is humbly submitted before this honorable. May I move ahead? Yes. It is humbly submitted before this honorable court that the right to freedom of speech and expression includes the right to disseminate information to a wide section of population, which also includes the right to access. It is submitted by the counsel for the petitioner that the content of electronic media can warrant regulation, yes. However, such regulation must be within the framework of Article 19, Subclause 2 of the Constitution. To substantiate the unconstitutionality of the Act, the Council would like to present a three-pronged submission. Firstly, that the Act does not pass the test of reasonableness. The Council for the petitioner humbly submits that the phrase reasonable restriction connotes that the limitation imposed on a person in enjoyment of the right should not be arbitrary or of excessive nature beyond what is required in the interests of the public. The word reasonable, Your Lordship, implies intelligent care and deliberation, that a choice of course, it should dictate reason. The impugned act, Your Lordships, through the course of its provisions, firstly, it defines what hate speech is in a very vague and ambiguous manner, and it further even criminalizes those activities. Secondly, it bestows unreasonable powers on police officers to arrest and detain any person who has allegedly committed any crime of hate speech. Your Lordships, we would like to refer to the case of Chintaman Rao versus the state of Madhya Pradesh, where the court had held that a legislation which arbitrarily or excessively invades the right cannot be, it basically said that if it excessively or arbitrarily invades the right, it should contain some quality of reasonableness. And that should also strike a proper balance between the fundamental freedom that has been guaranteed. Furthermore, Your Lordships, this is the last prong of my submission for this issue, is that there is an already existing framework to govern the offenses relating to hate speech. Statutory provisions, and particularly the penal law, provide sufficient remedy to curb the menace of hate speeches. Thus, a person aggrieved must resort to the remedy that is already been mentioned in the particular statute. Your Lordships, the last contention is that the root of the problem is not the absence of laws, but rather the lack of effective execution in this case. And therefore, it should make sure that those existing regulatory frameworks shall be first put into execution rather than creating another act which shall rather, in respect, confuse the citizens and create an apprehension in their minds. These are my submissions, Your Lordships. My co-counsel shall be dealing with issue 2 and issue 3 of the dispute. Yes, Your Lordship.
I want to ask one question.
Certainly, Your Lordship.
You are heavily on the section 19. Section 19 of the bill.
section 19 of the Act, Your Lordship.
Act. That is power bestowed to the police.
Certainly.
There has to be some, it is not unbridled powers. There are reasons, if it has any reason to believe that such messages or speech is being delivered or created, then only he can exercise that power.
Your Lordship, that
And otherwise also there is, in fundamental rights itself, there are citizens' rights protected from this pre-arrest, power of arrest.
certainly.
There is already protection granted in Constitution also.
Your Lordships, that issue shall be dealt by my co-counsel with respect to the
Otherwise,
powers of the Constitution.
how government can come to the conclusion that this message or speech is hate speech?
Certainly, Your Lordship. The problem is, and that was my last prong of the argument also, that there is already a statutory framework present. The enactment of this act is first of all defining online hate speech in a very vague and ambiguous manner, and therefore it is giving rise to subjective interpretation. It is giving the power to the authorities to define any hate speech, any speech or
Is
opinion
there
for that
any
matter.
other solution? We don't see any other solution for government.
Your Lordships,
Otherwise there will be threat to the nation's integrity.
certainly, Your Lordships, but in this case, that this should not be a reason to enact an unconstitutional law which shall restrict the fundamental rights of the citizens, Your Lordships. That should not be a reason just because there is no enforcement authorities. What this act is basically doing, is that it is restricting the freedom of speech and expression. That shall not be a reason. My co-counsel shall be dealing with the second and third issue, if there are no more questions.
Your co-counsel will deal with this aspect?
Yes.
Yes, all right.
Yes.
Permission to address the bench collectively as your lordships.
Yes.
Obliged, your lordships. Your lordships, as highlighted by my co-counsel, I shall be dealing with the second and third issue along with the prayer. With respect to the second issue, the council respectfully submits that the obligations that is being posed upon the data fiduciaries under this act, under the garb of sections 5 and 10, to monitor and share all user data violates the right to privacy by creating a surveillance state. To justify upon the same, the council shall argue a three-prong argument. As to the same, the first prong is that the impugned provisions, that is sections 5 and 10, violate the fundamental right to privacy, including in its information dimension. Now, if your lordships would kindly peruse section 5 given under the proposition, page number 6, your lordships.
Yes.
If your lordships are with me.
Yes.
So your lordships, section 5 particularly talks about the duty of significant data fiduciaries to monitor content. Now your lordships, over here, if subsection 2 is properly read, it particularly states that such data monitoring referred to shall be performed by deploying technology-based measures, including automated tools or artificial intelligence to identify and remove online hate speech content, effective machine learning tools in order to develop abilities of system to restrict the virality and propagation of online hate speech content. Now your lordship, before we go into the very understanding of these particular sections, we need to understand the role of significant data fiduciaries. Now the very role of significant data fiduciaries, and this terminology comes from the DPDP Act that was brought in by the government 2 years ago. So under the garb of DPDP Act, if a particular data fiduciary hosts a particular criteria, there is a threshold given under section 10. If that fivefold criteria is met, the government characterizes that particular data fiduciary as a significant data fiduciary. Now your lordship, the very problem with this section is that when a data principal, that is a normal individual of the state, gives some sort of data to the data fiduciary or a significant data fiduciary, that data is consented. And that when that consent is given, the angle of informational privacy also comes in. So the problem that is arising over here is that supposedly a person A consents.
Consent to what extent, mister?
Yes, Your Lordship. So if supposedly I am dealing with this one particular company and I'm buying something from there, so if I'm giving my data such as my name and my address details, that shall only be used for the purposes of delivering my particular product. If it is used beyond that purpose, then the DPDP Act gives some sort of remedy to the data principal to approach the courts or the mechanisms under that particular act as to mitigate that harm that was done to him. If may I proceed.
Yes, go ahead.
So, Your Lordships, the problem that is arising over here is the right to informational self-determination. So, when you're asking a significant data fiduciary who draws their powers from the DPDP Act to do something that is beyond the functions which establish them per se under the DPDP Act and which recognizes them per se, that per se is also violative. Because now when Section 10 of this impugned Act is read, which is given on page 8, it particularly states that the online regulatory authority under this particular act can direct such digital service providers, including significant data fiduciaries, to share non-personal as well as personal data of users. Now, Your Lordship, what is reasonable, as will also be illustrated by the respondents, reasonable in this context should have been that non-personal data that is being used for that particular purpose that individuals may have consented to. When you take that personal data of that individual, that is where the right to informational autonomy is violated. This very right to informational autonomy, Your Lordships, was highlighted in the case of R. Rajgopal versus State of Tamil Nadu, which is a case of this very honorable court. Now, Your Lordship, even in the Aadhaar case, that is the case Puttaswamy 2019 judgment, right to informational self-determination was stressed upon as the same protects individuals from compelled disclosure of personal data to the state absent specific legal justification and procedural safeguards. Now, this Section 10 Clause B of the impugned Act compels disclosure of personal user data alongside AI training models and proprietary algorithms to government agencies upon executive demand. What is also being violated over here is the fundamental right to trade and profession. So if supposedly what happened in Miss Neeti Srivastava's case, as also highlighted by my co-counsel, so over there she had developed this one particular program through her AI company, and that program was immediately taken by the government. So in this case, a particular right to conduct a trade and profession is also being hampered. Now, Your Lordship,
But in the nature of trade and commerce,
Yes, Your
or whatever activities you are doing,
Yes, Your Lordship.
you are on behalf of this Dr. Avinash Venkatraman.
No, Your Lordship, I am on the petitioners over here represent the Digital Rights Foundation, which represents all such data groups.
Yes, all such individuals.
Yes, Your Lordship.
Now this Dr. Avinash,
Yes, Your Lordship.
in the garb of floating his own information, his own contents,
Yes, Your Lordship.
he has circulated certain historical religious conflicts.
Yes, Your Lordship.
without understanding what harm it is likely to going to cause to the public at large,
Yes, Your Lordship.
spreading misconceptions. So government should have some mechanism to regulate such kind of unnecessary spreading of historical religious conflicts, which are not relevant even as on today. Many times spreading historical information is one thing, but spreading it intentionally to cause again unrest amongst the masses, how the government should have some mechanism to regulate that. You yourself are not acting responsibly, you are members of your association, so government has taken the measures to regulate your conduct. What's wrong in that?
All right. So, Your Lordship, I completely concede with the avertment that Your Lordship is making. But what needs to be understood over here, Your Lordship, is that even in the case of PUCL versus Union of India, which is a landmark case of telephone tapping, this very court had recognized that the right telephone tapping is normally impermissible, but it is permissible when a reasoned order is there. And that is what my second leg of argument also was, that there should be proportionality between the nexus of the act. So what the government was trying to achieve, it could have achieved through a reasoned order. What happened in this particular case was that Mr. Avinash was directly arrested without even determining. And as also argued by my co-counsel earlier, under the garb of which he is being accused over here, that is section 3, that section per se is also very irregularly worded to even try him under it. So this would give an umbrella set of criteria to the investigative agency to unnecessarily prosecute someone who could even publish that could also be something in good faith, just because it arouses the state's just because it arouses any anti-government content. The state could try him under this section because the words of this section are not carefully worded. If your lordship is satisfied.
All right, yes.
Yes, so your lordship, now I'd like to move on to the second prong of my argument, that these provisions fail the test of proportionality. Now, as highlighted by my co-counsel earlier, that in the 2019 Puttaswamy judgment, there was a threefold criteria that was given. That is, the statute should have legality, it should have a legitimate aim, and it should have proportionality. Now, as to the proportionality part, proportionality over here means which ensures a rational nexus between the objects and the means adopted to achieve them. Now, your lordships, the problem over here is when the same is applied to the particular facts, it may be seen that although the objective of preventing these online hate speech may be legitimate, as also stressed upon by your lordship, but section 5 and 10 are imposing blanket monitoring of all user data, because in per se they are doing that, they are also going against the provisions of the DPDP Act, and in doing so they are also taking in personal data. So supposedly, if there's a person who just randomly sends a WhatsApp message to his other friend, now in that particular case, the significant data fiduciary will also have that data, and pursuant to section 5 and pursuant to the obligations given to the significant data fiduciary under section 6, he could anytime share this data to government. Now at that point of time, who determines what is this objective criteria under which it will be mapped that this particular data is violative or it is infringing or it infringes the very scope of section 3. These things not being clarified vests arbitrary and umbrella set of powers, creating a surveillance state under the hands of the state. Yes, your lordship. Next, even in Shreya Singhal versus Union of India, this court had stated that automated content restriction without judicial oversight produces an impermissible chilling effect on protected expression. Targeted complaint and monitoring of specific flagged content is a less restrictive, equally effective alternative that the state has not adopted. Now, your lordships, even under the existing statutory frameworks, such as the IT Act and the BNS 2023, offences involving harmful or incendiary online content attract significantly lower penalties. Now, over here, if your lordships might observe that for section 3, the penalty has directly been given up to like 7 years. And then even upon the significant data fiduciaries, the penalties go all the way up to 100 crores. That is arbitrary in the sense because when we draw a comparative parallel, such as section 69A of the IT Act, which requires targeted blocking of content by the central government, if it infringes the sovereignty of India, in that case, there is no sort of criminal penalty. Against section 67 of the IT Act, which targets obscene content per se, the maximum punishment is up to 3 years. So there is not even any given rationale by the government to justify or proportionate that this particular 7 years is relevant to the mandate that they are providing under section 3. If your lordships are satisfied with the second prong of my argument, I'd like to
Go ahead.
So the third and the final prong of my argument relating to issue 2 is these provisions lack procedural safeguards and constitute a structural surveillance state. Now, your lordships, no fundamental right given under the constitution is absolute. Every one of them is subject to reasonable restrictions, and that is right under the constitutional law of Bandara. But the problem arises is that how this has to be interpreted. And for interpretation, the council heavily relies upon the case of PUCL versus Union of India. Now in PUCL versus Union of India, this court had held that any sort of intrusive state action touching upon the right to privacy must be governed by a procedure established by law and must afford the affected person an opportunity of representation. Now section 10 clause B fails this standard entirely without even justification or without even any sort of justification from the side of the accused. Any action can automatically be taken against him. The authority that is constituted under this act may on its own motion or on the application of any government agency compel disclosure of personal data. Over here, if the state was actually concerned about such sort of data, they should have also given an opportunity to normal individuals to file a complaint to this particular authority. But it is only the central government and it is only the authority on the suo motu jurisdiction who can per se take complaints under this act, showcasing its arbitrary nature. Now, your lordship, in the case of Manika Gandhi versus Union of India, that is the foremost judgment on Article 21 states that the procedure which deals with the modalities of regulating, restricting or even rejecting a fundamental right has to be fair, not foolish, and it should be carefully designed to effectuate, not to subvert the substantive right itself. Thus, understood, the procedure must rule out anything arbitrary or bizarre. a valuable constitutional right cannot be canalized can only be canalized by civilized processes. Again, even in the case of Ram Jethmalani versus Union of India, which is a 2011 judgment of this very court, the court noted that the constitutional norm requires that state surveillance be accompanied by adequate procedural safeguard, which are conspicuously absent in the case. These impugned provisions of section 5 and 10 cannot be read in isolation. When read with section 6 clause D and other sections, it is seen that these provisions constitute a comprehensive system of executive surveillance over online speech. This architecture converts private data fiduciaries created under the DPDP Act into de facto instruments of state instrumentality, which irreparably burdens the fundamental right of privacy of every internet user in Vandara. If your lordships are satisfied with the second issue, the council would like to move it.
Yes.
Yes, Your Lordship. So, the third and final issue that the council seeks to argue before this honorable court is that the powers bestowed upon police officers under section 19 amount to unreasonably excessive grant of powers. This is the same question, Your Lordship, that you had posed to my co-counsel. So, the argument that I'm making here is threefold. Since any section or any statute, when it has to pass the test of constitutionality, has to go through the test of three articles, that is Article 14, Article 19 and Article 21, as also noted in the case of Maneka Gandhi. So, therefore, the first part is that section 19 confers unguided and manifestly arbitrary power in violation of Article 14. Now, when the same is perused, it may be seen that it empowers any police officer not below the rank of sub-inspector to arrest without warrant any individual accused of creating or disseminating content under section 3 and to detain such person for a period not exceeding 180 days pending investigation and filing of a charge sheet. Now, Your Lordship, the problem over here needs to be identified through the doctrine of manifest arbitrariness that was laid down by this very court in the case of Shaira Bano versus Union of India, where the court noted that manifest arbitrariness is something when the law is capricious or it does not have a legitimate or a fair objective. Now, the reason the council states upon the same is that when we look at parallel provisions, such as under the Bharatiya Nagrik Suraksha Sanhita, that is specifically section 35, which allows the police the power to arrest without warrant, and read with section 187, that allows the court for detention of any accused beyond the reasonable period of 24 hours. Over there also the maximum period given under BNSS is 90 days, and that 90 days is also given in cases where it's murder or there are offences relating to life imprisonment or death penalty. In those cases, the investigation time period is extended up to 90 days. Over here, the government without any reasonable nexus has totally exceeded this criteria by bypassing it and going up to 180 days. Even the Constitution, Your Lordship, under the garb of Article 22 states that 90 days is the maximum period for which detention can be given. So over here, it is in clear violation of the same. And the second problem as to why it violates Article 14 is grounded under administrative law. Now, administrative law, through the case of INRE Delhi Laws Act, clearly dictates that essential legislative functions cannot be abdicated. Now, this abdication is taking place. Again, for the same, the council would like to place a reliance between section 35 of BNSS and section 19 of this particular act. Now, section 35 of the BNSS, Your Lordships, particularly provides that if there is some sort of reasonable suspicion, there is some sort of complaint, or there is apprehension upon the police officer that a crime has been committed, then in line with the Arnesh Kumar checklist, an arrest without warrant may be made. That too only if necessary, and that too only if the party refuses to come upon the notice that has been issued to the party. Over here, Your Lordships, the problem is the police is completely acting upon a subjective criteria of satisfaction. There is no objective criteria. The legislature therefore has totally abdicated its responsibility of doing so, and in doing so has put through arbitrariness by virtue of this section.
What exactly is your argument about essential legislative function aspect?
Yes, Your Lordship. So, essential legislative functions basically means that whenever a statute is being made and a delegated legislation under it needs to be given, the legislature is mandated to set forth a criteria, a threshold under which the executive may make further regulations or it may act according to it. Over here, what is happening is that the police has been given blanket powers without subjective satisfaction of any sort of criteria.
We are here concerned with the Parent Act.
Yes, Your Lordship.
Not the delegated piece of legislation.
Yes, Your Lordship. So, this is the Parent Act, where without giving any objective criteria under section 19, the legislature has abdicated its responsibility. Ideally, it should have given, like I have given an example of section 35 of BNSS, where there is a threefold satisfaction that needs to be done. That is, there should be reasonable apprehension, or there should be some reasonable...
So, but then where is the cause of action to invoke that concept of essential legislative function? Unless there is any piece of delegated legislation which goes beyond the Parent Act,
Yes,
then
Your
only that issue will arise.
Your Lordship, essential, that is
At
one-
this stage, on what basis you are invoking that concept?
Your Lordship, I am invoking that concept on the ground that the powers vested upon an executive authority are that also becomes a part of excessive delegation. What I'm trying to pose over here is also excessive delegation of powers given to the executive authority. Over here, the police as an instrument is working without any objective criteria. It can directly go and arrest a person on a subjective satisfaction. That is what the council is asserting.
Police are not given the powers to frame any delegated piece of legislation.
Yes, Your Lordship.
They are given powers to arrest, that to subject to their satisfaction. You have invoked the concept of essential legislative functions.
Yes, Your Lordship.
How is that relevant here?
Your Lordship, essential legislative functions cannot be abdicated, meaning that in the context that I'm trying to pose is that when any sort of legislation is made, the council might have incorrectly placed it, the council will just correct himself. So what the council is seeking to present is that when a legislation is made, and under that an executive wing has to work upon, that executive wing has to work upon some fetters. A fetter must be set forth by the legislature. When that fetter is not set forth and the particular executive authority acts without some fetters, that is also violative of Article 14. That is what the council seeks to present. If your lordships are satisfied.
Now, is there any delegated legislation which has come into force, which is beyond the parameters of the Parent Act?
Your Lordship, the delegated legislation is yet to come. The government had directly implemented the act without the rules.
So there could be some delegated legislation which may come based on the unfettered powers under this act. Is it your argument?
Your Lordship, the argument is that even under Section 19, the powers that has been given are unfettered, and that is also incorrect under administrative law. This is the principle that the council is trying to state, that even unfettered...
Whether the powers are unfettered or not,
Yes,
will
sir.
become clear after any piece of legislation comes into existence.
Yes,
Piece of delegated
Yes,
legislation.
Lordship.
Without that, how can we say at this stage that the powers are unfettered?
Your Lordship, it's unfettered because there is no criteria for the police to act upon before it arrests a person. It can directly, upon its own subjective satisfaction, arrest a person, even considering the general law, that is that is Bharatiya Nagrik Suraksha Sanhita, under the garb of Section 35, mandates that there is this threefold test coupled with the Arnesh Kumar checklist that needs to be followed before an arrest without warrant can be made. That is not there in this particular scenario. That is what the council is seeking to present. Yes. Your Lordships, this is the first fold of my argument. If you're satisfied with the same,
Yes, go ahead.
Yes, Your Lordship. So the second fold of my argument is this Section 19 also deprives personal liberty through a procedure that is neither just, fair or reasonable and is contrary to Article 21. Now, Your Lordships, Article 21 guarantees that no person shall be deprived of personal liberty except according to a just, fair and reasonable procedure. This interpretation flows from the case of Maneka Gandhi versus Union of India. Now, Section 19 over here authorizes detention up to 180 days pending investigation. Such prolonged pre-trial detention is incarcerative in nature and is punitive in effect and undermines the presumption of innocence. Now, the problem over here is that the council nowhere denies that pre-trial detention is not allowed. But the problem is that when pre-trial detention is done, the same has to be clarified upon by the magistrate. Within 24 hours, he has to be presented before the magistrate, and post that the pre-trial detention is extended. There is no reasonable nexus to showcase that the detention may be done up to 180 days. Now, Your Lordship, for that, I'll take an example of the... yes, Your Lordship. So, what happens is that... Yes, Your Lordship. So, the problem over here is that when we speak about the 180-day period, complement it with the 7 years imprisonment, even in statutes such as the UAPA and in the statutes such as the NSA, the reason why a detention, such as in UAPA, the maximum detention period is 180 days. But that 180-day detention period is there because the penalty over there is up to life imprisonment. Here, the imprisonment period is merely 7 years, and still they are giving a detention up to 180-day period. So there is no reasonable nexus between the same, and the procedure established by law over here is not just, fair and reasonable.
The 180 days for investigation.
Yes, Your Ladyship.
It is preventive detention. Similarly, similar is the provision which is under Constitution.
Yes, Your
It is
Ladyship.
preventive detention on satisfaction that he is accused of the said hate speech, creating hate speech and spreading it. For that reason, he will be under arrest, but it is not punishment. It is preventive detention.
So section 19 is a kind of preventive detention,
Yes.
which is in tune with Article 22 of the Constitution. What's wrong with that?
No, Your Lordship, it's not in tune with the Article 22 because Article 22 mandates that the pre-trial detention should not exceed a period of 90 days. Only in specified circumstances can it exceed. That's why I had also taken an example of UAPA, showcasing a comparison that in UAPA, where the offences are life imprisonment and death penalty, over there, the maximum pre-trial detention period allowed is 180 days. Over here, where the imprisonment period is merely 7 years, that is the maximum that is given by virtue of this act, still they are given a 180-day period. So comparison to the existing laws of the country, the same is not proportionate and it is not reasonable, because under the garb of this act, it is not always that only terrorists would come into being, but there could be journalists, there could be normal social media influencers. So in that scenario, will everybody succumb to such high thresholds without having a proportionate nexus? That is what the council is seeking to present. Your Ladyship.
No person beyond nation. Beyond nation, there is no.
I totally concede.
Even journalist, even
I concede to the fact, Your Ladyship, but what law must also see to the law must also protect that little man is also a fundamental principle, and therefore this code sits upon. If Your Lordship is just satisfied, I'd like to present the last prong of my argument. If you could provide me with an extension. Yes. So, Your Lordships, the last prong of my argument is that this Section 19 also fails the free speech and proportionality standard given under Article 19, Clause 1, Clause A. Now, the arrest of Professor Venkataraman, as also highlighted earlier for academic analysis, demonstrates the chilling effect of Section 19. When online content is met with immediate incarceration, academic and journalistic discourse is suppressed. In Shreya Singhal versus Union of India, this court had struck down Section 66A because of its vague speech-based offences. It chilled legitimate expression, and this court, in the very case of Bennett Coleman versus Union of India, had recognized that academic discourse and freedom of press are integral to this article. So even assuming prevention of online hate speech is a legitimate aim, prolonged detention without necessity is the least restrictive means that the state could have employed. Existing criminal provisions addressing incitement operate with judicial safeguards. Hence, Section 19 fails the necessity and balancing prongs of proportionality. If Your Lordships are satisfied with my arguments, I'd like to move ahead with the prayer.
Yes.
In light of the issues raised, arguments advanced and authorities cited, it is humbly requested that this Honorable Court may be pleased to judge and declare and to issue a writ of mandamus under Article 32 of the Constitution or any other writ, order or direction declaring that the Section 3 of the Online Hate Speech Act is unconstitutional. 2. To issue a writ of mandamus or any other appropriate writ declaring that the obligations imposed under Section 5 read with Section 10 of the Online Hate Speech Act are unconstitutional. 3rd, issue a writ of mandamus or any other appropriate writ declaring that Section 19 of the Online Hate Speech Act 2024 are unconstitutional. And 4th and last, issue a writ, order or direction declaring that the Online Hate Speech Act 2024 is unconstitutional in its entirety, and or pass any other order that this Honorable Court deems fit in the best interest of justice, equity and good conscience. And for this act, the petitioner shall duty bound forever pay. It was an honor arguing before you, Lordship.
What is the status of your organization, petitioner organization?
Yes, Your Lordship, so it's a digital right foundation that works to, the facts over here are silent upon it, but it works towards the digital rights of the citizens of Bandara.
Is it a registered association? Is it required to be to file this petition?
Yeah, no, Your Lordship, it does not have to be a registered foundation to file a petition before this.
So even an unregistered association can file such kind of petition?
So, Your Lordship, even a person, it could also be a body of individuals which is not registered at this point of time. On the other hand, because the facts are silent upon this, the council cannot substantiate as to that fact, but even a body of individuals coming together.
You have alleged violation of fundamental rights of individuals.
Yes, Your Lordship.
And the petition is filed by an association.
Yes, Your Lordship.
So if this association is unregistered, how can it get a right to agitate an issue with respect to violation of individual rights of its members?
Your Lordship, it's not stressing upon the individual rights of the members. It is a generic petition for the protection of digital rights of the citizens all across the country. It's not specifically stressing upon the rights of Ms. Neeti Srivastava and Professor Venkataraman, but it is merely been joined by Professor Venkataraman and Ms. Srivastava's company. Otherwise, it's a independent organization working towards digital rights, Your Lordship.
All right. Yes, have you finished?
Yes, Your Lordship.
Okay.
It was an honor.
For further queries, we may call upon you again.
Yes.
Yes. Yes.
Good afternoon to the Honorable Bench. I am the counsel on behalf of the respondent. If it may please, the counsel seeks permission to address the bench collectively as Your Lordship.
Yes.
Obliged, Your Lordship. Your Lordship, the counsel is appearing before this Honorable Court in the matter of Digital Rights Foundation and others versus Republic of Vandhara. Your Lordship, there are four main issues involved in this present case. The counsel will be dealing with the first and the third issue, and the co-counsel will be dealing with the second and the fourth issue. If Your Lordships are well versed with the facts of the case, the counsel seeks permission to begin with the first
Go
issue.
ahead. Yes.
Obliged, Your Lordship. So, Your Lordship, the first issue is whether the definition under Section 3 is overbroad and vague, thereby in violation of the provisions of the Constitution. Your Lordship, the counsel humbly submits before this Honorable Court that the provision is neither overbroad nor vague, and it does not violate any provisions of the Constitution. Your Lordship, the counsel would be establishing this contention on two major grounds. Your Lordship, my first contention is the expressions are defined in the statute itself. As Your Lordship, a law can be termed vague when it fails to define the prohibited conduct or leaves citizen uncertain that what behavior is punishable. But Your Lordship, in the present case of Online Hate Speech Prevention Act, Section 3 clearly identifies the specific form of online hate speech. As Your Lordship, it includes promotion of religious hostility and discrimination, denigrates a individual or a group based on their protected characteristics, and speech threatening national security, public order and sovereignty. Your Lordship, these provisions requires the intentional publication and dissemination, thereby requiring the essential requirement of mens rea, Your Lordship. And for this contention, the counsel would like to refer the case of K.A. Abbas versus Union of India, where Your Lordship, the Honorable Supreme Court held that the statute can be unconstitutional when the authorities are left with the boundless sea of uncertainty. However, Your Lordship, in the present case, the provision defines the prohibited conduct, Your Lordship. Both citizen and enforcement authorities are adequately guided. Thereby, Your Lordship, therefore, Your Lordship, the allegation of vagueness is unfounded in the present case, Your Lordship. My further submission is that, Your Lordship, that the alleged ambiguity must be resolved with the contextual interpretation rather than striking down it, Your Lordship. The Section 3 must be read with the light of the object of the Act, as Section 3 of Online Hate Speech Prevention Act is to prevent the online hate speech which threatening communal harmony, national security and public order. And for this contention, Your Lordship may refer to the page number 1, paragraph number 3 of the Moot proposition, where it is mentioned that the Republic of Vandhara witnessed multiple incidents of mass violence allegedly triggered by the social media post. There are reported foreign digital interference in the election during 2024, and Your Lordship, the most important thing is the intelligence have warned that the terrorist organizations are using the online platforms to spread their ideology, Your Lordship. And this particular situation, there is a massive need of this kind of a statute, Your Lordship. If Your Lordships are satisfied, the council would like to proceed with the next contention.
You mean to say Section 3 itself is clear and it has to be understood and read in the parameters in tune with the aims and objects of the act.
Indeed, your lordship.
But then the provision,
Indeed, your lordship.
read the provision. The provision starts with the words a user who intentionally uses,
Indeed, your lordship. Intentionally.
publishes. Now in the case in question,
Indeed, your lordship.
when those persons who have, according to the government, have
Indeed,
indulged in certain spreading of certain posts,
Indeed, your lordship.
where are the reasons for concluding that they have intentionally done that? What kind of inquiry was conducted with respect to that Dr. Avinash and that other lady?
Indeed, your lordship. Your lordship, the question regarding the Professor Avinash Venkatraman and the intentional, your lordship, intention must, if someone is spreading the online hate speech, the intention must be clear to incorporate the essential requirement of mens rea, your lordship. And if someone is doing for the good faith, that is mentioned in the section 4 of this act, your lordship, that act done in a good faith, which contains the academic discussions, political criticism, satire, or just doing things in the good faith. But if someone intentionally do to provoke harm, provoke communal violence or the riots, in such situation they could be criminalized in the particular act, your lordship.
Without conducting an inquiry as to whether it is intentional or not,
So
no conclusions can be drawn to arrest or take any kind of action against those persons. What kind of inquiry was conducted with respect to these persons?
Your lordship, as after the report under section 3, there must be a detention period of 180 days. In that particular time, there is an investigation time to investigate that is a intentional way of promoting the online hate speech or to make a communal violence. And this is important because, your lordship, as it is mentioned in the Moot proposition, that terrorist organizations using the online platforms to spread their ideology, which would harm the national security, your lordship, and that's the reason it is very
Mr.
essential.
Counsel,
Indeed, your
even
ladyship.
section 19 doesn't make it clear whether there has to be satisfaction to the police officer or not. He can simply arrest on accusation. So where is the here the provision is arbitrary.
Certainly not, your lordship, as after the arrest under section 19, the accused person must be present to the magistrate. If the judicial authorities continues the detention, the accused person also have the right to apply for the bail, your lordship, your ladyship. So, if the judicial authorities continues the detention, there might be something which would be harm to the, and which may harm. As your lordship, Avinash was arrested after the investigation, and it is proved after the trial, your lordship. May I proceed?
Apart from section,
Indeed, your lordship.
when we come to section 19,
Indeed, your lordship.
it provides that any police officer not below rank of so and so may arrest without warrant.
Indeed, your lordship.
What about satisfaction of the police officer?
As your lordship, this is not unconstitutional because in Bharatiya Nagrik Suraksha Samhita under section 35, police authorities also have the right to arrest a person without warrant in the cognizable offence, your lordship. So this is very legitimate.
So doesn't it give unbridled powers with the police officers?
Certainly not. It is not the unnecessary power to the police officer, your lordship. It is justified, and that is my issue number 3, which would be I am going to dealt, your lordship. If you want, I could dealt now.
Oh, in that case also, there has to be reason to believe that such offences occurred or committed. Then only he can arrest without warrant. So what is here there is no protection or safeguards.
Pardon, your
They
ladyship.
arrest anybody.
Your ladyship, after looking upon the intensity of that online post or of the information which has been posted in the social media content, after looking upon the intensity and the report which has been made under section 3, then only he would be arrested.
So
your
who
lordship.
will decide the intensity?
After in the period of the investigation, your lordship. As your lordship, after the arrest, the accused person may be presented to the magistrate. There would be a judicial authority to decide all of those things after the arrest, your lordship.
See, section 19 empowers that police officer
Indeed, Your Lordship.
to arrest a person without
Indeed, Your Lordship.
content defined under section 3 and hold such person in detention for a period not exceeding 180 days
Indeed, Your
before
Lordship.
taking such a drastic action. What mechanism is provided under the act to control that police officer?
As for the question, Your Lordship, about the detention up to 180 days, Your Lordship, the detention up to 180 days is justified, Your Lordship. As Your Lordship, the investigation process is
Only because
after the report filing against under the section 19, under section 19, the police officer may arrest the accused person. Your Lordship, as even in the present case, Professor Avinash Venkat Raman was arrested after filing the charge, after filing the case again under section 19, as he has provoked the section. May I proceed, Your Lordship? May I proceed, Your Lordship? So, Your Lordship, my next contention is that it does not criminalize the protected speech. As Your Lordship, it is submitted that the impugned provision does not suffer from the vice of weakness and it does not criminalize the protected speech. However, Your Lordship, it targets the speech which promotes hostility, discrimination or violence against the protected group, which falls within the ambit of permissible restriction under Article 19 Clause 2, specifically, Your Lordship, public order and incitement of the offence. And as Your Lordship, the learned counsel for the petitioner have mentioned about the case of Shreya Singhal versus Union of India, where the Honorable Supreme Court struck down Section 66A because it criminalized mere discussion and advocacy without any proximity connection to the public order. However, Your Lordship, in the present case, it is differentiable, Your Lordship. Your Lordship, it penalizes only speech which intentionally, Your Lordship, intentionally promotes or promotes hatred or hostility, Your Lordship, thereby maintaining the direct nexus to the reasonable restriction under Article 19 Clause 2, Your Lordship. Therefore, Your Lordship, the Council humbly submits before this Honorable Court that the definition under Section 3 is neither overbroad nor vague and it does not violate any provisions of the Constitution, Your Lordship. If Your Lordships are satisfied with the pleading submitted in the third issue, the Council seeks permission to begin with.
what about response to their contentions that the provision is violative of Article 21?
Your Lordship, it does not violate the Article 21 of the Constitution, that is right to life and personal liberty. As Your Lordship, this act is related to the online hate speech, which is intentionally promote or designate, Your Lordship, and that would be dealt by my co-counsel in her issue, Your Lordship.
Co-counsel will deal with that aspect.
Indeed, Your Lordship. If Your Lordships are satisfied with the pleading submitted in the first issue, the Council seeks permission to begin with the third issue.
Permission for what?
To proceed with the third issue, Your Lordship. Obliged, Your Lordship. Your Lordship, the third issue is whether the power bestowed on police officer under Section 19 amounts to unreasonable excessive grant of power. Your Lordship, the Council humbly submits before this Honorable Court that Section 19 of Online Hate Speech Prevention Act is constitutionally valid as it does not amount to any excessive grant of power. Your Lordship, the legislature has enacted Online Hate Speech Prevention Act to address the growing threat of digital misinformation, communal hatred and violence triggered by the online hate speech. Your Lordship, the online platform enable rapid dissemination of harmful content, enable inciting of communal violence, threatening national unity or disrupting the public order. As Your Lordship, this Honorable Court has consistently held that national security and public order are the legitimate ground for the restriction of speech and liberty. And for this contention, the Council would like to refer the case of Ram Manohar Lohia versus State of Bihar. For this, Your Lordship may refer to page number 23, para number 47 of the memorial of the respondent, Your Lordship, where the Honorable Supreme Court held that state may impose restriction when speech threatening public order. As Your Lordship, online hate speech often spread faster than the traditional way of communication, Your Lordship, which is evident in the present case as the country witnessed multiple incidents of mass violence allegedly triggered by the social media post, and the intelligence have warned that terrorists are using the online platform to spread their ideology. Therefore, Your Lordship, Section 19 must be interpreted as the legitimate legislative response to the serious societal issue, Your Lordship. Further, Your Lordship, I have also already submitted that arrest without warrant is not unconstitutional. Even in Bharatiya Nagrik Suraksha Samhita, under Section 35, police have the authority to arrest a person without any warrant. My further submission is that, Your Lordship, that under Section 19, arrest person must be present to the magistrate.
Before you go to that,
Indeed. Indeed.
accordance with the position of law as laid down in Maneka Gandhi's case.
Your Lordship, the Menaka Gandhi case held that the procedure must deprive the personal liberty just, fair and reasonable. Your Lordship, the present provision is fair and reasonable, Your Lordship, as it gives all the fundamental rights to the citizen. It just to regulate the online hate speech. This provision has been made, Your Lordship. May I proceed further, Your Lordship?
Yes.
Your Lordship, the Council would like to refer the case of Ahmad Noor Mohammad Bhatti versus State of Gujarat. Your Lordship, may refer to the para number 10 of the judgment, the highlighted portion, Your Lordship. Your Lordship, the Honorable Supreme Court held that the provision cannot be held unconstitutional merely because authority vested with power may abuse his authority. Therefore, Your Lordship, the mere existence of police power does not violate the provisions of the Constitution. Your Lordship, the Council is done with the pleadings. If Your Lordship have no further question, then my co-counsel will be dealing with the rest of the issues, Your Lordship.
Are you taking
as Your Lordship, these
presumption about constitutionality of a statute?
As Your Lordship, this statute does not violate any provisions of the Constitution which I am submitting here, Your Lordship.
This concept of
for apology for this, Your Lordship.
all right.
Your Lordship, there is a presumption that statute is constitutional unless it's proved unconstitutional, Your Lordship.
Are you taking help of this?
Indeed, Your Lordship. Much obliged, Your Lordship. It was an honor arguing before this honorable bench, Your Lordship.
May it please the Honorable Court, I appear on behalf of the respondent to submit that Section 5 and Section 10 of the Online Hate Speech Prevention Act 2024 are not unconstitutional. Your Lordship, the Council would be establishing this contention on two major grounds. The first ground is that the right to privacy is not absolute. Your Lordship, the Council, for this contention, Your Lordship may refer to the judgment in case Puttaswamy versus Union of India. Your Lordship may refer to page 2 of the judgment. This Honorable Court in case Puttaswamy versus Union of India held that right to privacy cannot be impinged without a just, fair and reasonable law. It has to fulfill the test of proportionality, that is existence of a law, must serve a legitimate state aim and proportionality. Your Lordship, the Council humbly submits that in the present case, the first requirement, that is legality, is being fulfilled, as Section 5 and Section 10 are a part of duly enacted legislation passed by the competent legislature and not an arbitrary executive action. Further, the second ground, that is the provisions must serve a legitimate state aim. The council humbly submits that these provisions are enacted to combat online hate speech, which is defined under section 3 as the speech which threatens the sovereignty and or integrity of Bandhara, security of the state, friendly relations with foreign states, or public order. Your Lordships, these fall squarely within the recognized grounds of restrictions under Article 19, Clause 2. Further, Your Lordships, the doctrine of positive obligations of the state requires the government to take proactive measures to protect citizens from harm, and thus the present act was enacted in order to curb the menace of online hate speech and violence. Further, Your Lordships, the third necessary limb, that is the provisions should be proportionate and narrowly tailored. Your Lordship, the Council humbly submits that Section 5 aims at monitoring unlawful content. Thus, AI-based monitoring directly targets online hate speech content to restrict their virality and propagation. Further, Section 10 empowers authorities to issue content takedown orders as hate speech spreads rapidly online and prompt actions are necessary, and without access to user data and platform algorithms, investigation and enforcement becomes impossible. Your Lordships, therefore, both the provisions are necessary to achieve the state aim. In addition to that, Section 5 and Section 10 of the Online Hate Speech Prevention Act are adopted as the least restrictive means. Section 5 allows only automated and AI-based and content-focused monitoring to identify and remove online hate speech content. There is no human intrusion. Therefore, there is no arbitrary discretionary power given to the executive. Further, Your Lordships, the proviso to Section 5 states that all such measures shall be in consonance and consideration with the interest of free speech and expression. Section 5 thereby crucially limits the language complying with the fundamental rights. Further, Your Lordship, Section 10 is also subject to several procedural safeguards. Your Lordships,
Madam,
Indeed.
when you are talking about Section 10,
Indeed.
Clause
Your
B,
Indeed, Your Lordships.
under that clause, Section 10B, directions can be issued to any significant data fiduciary to share non-personal as well as personal data of users or intermediaries.
Indeed, Your Lordship.
What authority, how do you regulate the misuse of this personal data? What mechanism is provided in the Act?
Your Lordships, the personal data of the users are only used for a specific purpose of identifying online hate speech content and the identity of the accused who has propagated online hate speech. This is the only purpose for which data is being used in this Act, Your Lordship. And therefore, there is no other purpose for which the personal data of the users is being used.
But how will that be regulated, that the personal data will be used only for that purpose? What restrictions are there inbuilt in the enactment?
Your Lordships, the data is provided only after the authorities ask the data fiduciaries to share it, and the authorities who ask for the data are a statutory authority under Section 9 of the Act, Your Lordships. They have only, the data is being only used for this purpose only.
Do you mean to say that there is a presumption that the statutory authorities will act within their bounds?
Certainly, Your Lordships, because the objective of this Act is to curb online hate speech, and the data is only used for that purpose, to identify users who propagates or promotes online hatred.
But there are instances that the authorities have misused the provisions. They have straightway arrested Dr. Avinash Venkatraman.
Your Lordships, Section 10 is also subject to several procedural safeguards. The authority empowered under Section 10 is a statutory authority established under Section 9 of the Act, and Section 9, subsection 3 of the Act mandates that the authority shall give a reasonable opportunity to a person for making a representation complying with the principle of natural justice. Further, regarding the statutory authority misusing the law, further Section 11 enables appeal against the decision of the authority, Your Lordship. And Section 12 also mandates due process to be followed by authorities before making a decision.
Yes.
Coming to the second ground, Your Lordship, it is submitted that impugned act does not create a surveillance state as alleged by the petitioners. It is submitted that a surveillance state involves continuous blanket monitoring of individuals.
Before provided that the authority on its own motion or on the application of any government agency. Don't you think that this again gives unbridled powers with the authority to act on its own motion whenever it thinks fit?
Certainly not, Your Lordships, because the authority has the duty to protect users from online hate speech and to regulate online hate speech. This is in consonance with their duty, Your Lordships. So it is necessary to give such powers to authority.
Even on the application of any government agency. So simply because some government agency submit some application to supply details of personal data, the authority will straightway share that data. How do you regulate this entire conduct of the regulatory authority?
Your Lordship, there is a appeal mechanism given in Section 11 of the Act to appeal against the decisions of the authority. And therefore, the authorities under Section 12 is also bound to follow the due process of law as it is given as a power of the civil court.
All right, go ahead.
Much obliged. Your Lordships, it is submitted that a surveillance state involves continuous blanket monitoring of individuals without legal safeguards. Section 10, however, requires directions by authority only in cases of violation and is subject to appeal as already submitted. Your Lordship, the impugned act does not monitor individuals. It merely imposes compliance obligation on digital platforms to prevent online hate speech. If Your Lordships are satisfied with the pleading submitted in the second issue, Council seeks permission to begin with the fourth issue. Much obliged. The Council humbly submits that the impugned act does not upset the constitutional balance, but rather harmonizes the fundamental rights with reasonable restrictions. Your Lordships, in the present case, the restrictions on free speech are reasonable. Section 3 penalizes only speeches that promotes hatred or violence or threatens public order. And Section 4 explicitly protects academic inquiry, artistic expression, and fair reporting. This ensures that legitimate speech is safeguarded and only harmful is restricted. Further, Section 6 of the Act, Section 6, Clause G of the Act of the Online Hate Speech Prevention Act protects unintentional offensive speeches by mandating significant data fiduciaries to regularly send correction notices to the users in case of unintentional and non-provocative online hate speech is provocated on digital platforms. This is how the Act protects the unintentional speeches by the users by sending them regular notices to take it down. Further, the Act satisfies Article 21 as the Act enable minimal intrusion with strong safeguards as already established with the case Puttaswamy case. Further, Your Lordships, the Act reflects constitutional morality as the state has the duty to protect citizens from harm and ensure dignity and equality. Hate speeches undermines fraternity, equality, and social stability. Hence, the Act advances constitutional values and not suppress them. Further, Your Lordships, the Council humbly prays before this Honorable Court to, in the light of the arguments advanced, to dismiss the petition of the presented by the petitioners.
What is your response?
Your Your Lordship, see, in this regard, the Council humbly submits that penalties are not disproportionate; they are proportionate as under the Act. As the Act ensures deterrence, the penalties ensure deterrence and compliance. Your Lordships, without enforcement, the Act would be ineffective. The legislature has wide discretion in prescribing punishment based on the gravity of harm. Online hate speeches has the capacity to cause harm due to scale and reach of the digital platforms. And one such example can be seen in the present case as well. Your Lordship may in this regard refer to the paragraph 3 of the Moot proposition. In the present case, Your Lordship, Vandhara witnessed several incidents of mass violence, allegedly triggered by the social media post. Further, there were documented cases of foreign interference in state elections through sophisticated disinformation campaigns and terrorist organizations using online platforms to spread their ideologies. Regarding this, Your Lordships, given the magnitude of harm, the penalties are commensurate and not excessive.
Come to section 14. Any significant data fiduciary failing to observe its obligations under section 5, that is only in nature of obligation, shall be liable to pay by way of penalty failure to comply with the obligation which is in the nature of a duty,
Your Lordship,
and the punishment is about up to 100 crore rupees. How do you justify this provision?
Your Lordship,
With respect to proportionality, with respect to vice of arbitrariness.
Your Lordship's data fiduciaries in the present case plays an important role in enforcement of this Act. Your Lordship, data fiduciaries are responsible for monitoring all the data and giving it to the authorities to prevent online hate speech. If the significant data fiduciaries fails to observe its obligation, the entire purpose of the Act would be there would be no purpose of the Act. There would be problems with enforcement of the Act, and it would render it void, because the enforcement would not take place if data fiduciaries are not observing their obligations, and therefore the penalty is proportionate to the harm that may be caused if online hate speech is not regulated.
Section 14 again.
Indeed, Your Lordships.
It refers to significant data fiduciary failing to observe obligations under section 5.
Indeed.
Now come to section 5.
Indeed, Your Lordship.
Does it deal with obligations,
Your Lordships.
or any other section deal with obligations?
Your Lordships, the section 6 deals with obligations, that every significant data fiduciary shall implement appropriate measures to prevent
So
the
section 6 provides for obligations.
Indeed.
Section 5 provides for duties of the significant data fiduciaries to
Indeed, Your
monitor
Lordship.
the content.
Indeed, Your Lordship.
Your section 14 is referring to obligations
Indeed, Your Lordships.
and at the same time referring to section 5.
Council apologize for the same, but the obligations given under section 6 are the core mechanisms, or the in this obligation, the significant data fiduciaries plays an important role in implementing the purpose of the Act, Your Lordship.
So this reference to section 5 in section 14 while talking about obligations,
Indeed, Your Lordship.
is it correct or incorrect?
Your Lordship, the data fiduciary do have the duty to monitor content for the purpose of preventing online hate speech. Section 6 also puts obligation on the significant data fiduciaries to take appropriate measure to prevent the spread of online hate speech. They are in addition to each other, like for
Severe penalty is being provided under
Indeed,
section
Your
14 to the extent of 100 crores.
Indeed, Your
And that section 14 refers to section 5, but it refers to obligations.
Your
So
Lordship,
this major provision having drastic consequences, don't you think that the provision itself is flawed?
Your Lordship, even if there is a flaw, Section 23 gives powers to the authorities section of the Act. Section 23 of the Act gives power to remove difficulties. If any difficulties arises in giving effect to the provisions of the Act, the central government may make such order or give. Indeed. Your Lordship, the submission is that even if there is some difficulties, the Act cannot be held unconstitutional. The central government may make such rules to remove these difficulties. Your Lordship, but that doesn't make the Act unconstitutional. We have the power to remove difficulties under Section 23. And, pardon?
For removing such kind of anomaly?
Your Lordship, Section 23 provides for power to remove difficulties if difficulties arises in giving effect to the provisions of this Act. Also, under Section 24, power to make rules, the central government may, by notification in the official gazette, make rules for carrying out the purpose of this Act.
No, Section 23 deals with if any difficulty arises in giving effect to the provisions of this Act.
Indeed, Your Lordship.
It doesn't say that in case there is any anomalous provision, any flawed provision, then the court or the authorities will have their discretion to implement it or work out it according to their whims.
Your Lordship, that is just a clerical mistake that can be improvised, but that doesn't make the whole Act unconstitutional for a simple
All right.
flaw. Much obliged, Your Lordship.
All right.
Your Lordship, the council is done with the pleadings. If Your Lordship may allow.
Yes.
Much obliged, Your Lordships. It was an honor arguing before this honorable.
Yes.
The council would once again like to seek permission to address the court.
Yes.
Your Lordships, before I begin, it becomes imperative as an officer of court to highlight some of the misguidings done by the opposite counsel to this court, and it is imperative so. First being, the counsel had argued that Section 12 talks about due process, but if your Lordships could peruse Section 12 specifically, this section particularly caters to the powers of the online regulatory authority and the appellate tribunal to have powers of the civil court. It does not talk about due process in the sense, unless the opposite counsel are construing them in a very, very wide sense, which is not possible in this particular scenario. And secondly, your Lordships, initially only the first speaker from the opposite side counsel had pointed out that Professor Venkataraman, in his case, a charge sheet was filed. But the very purpose with which they have brought in Section 19 says that that particular provision is there so that pending charge sheet and pending investigation, someone can be detained for 180 days, and even the proposition nowhere highlights that there was a charge sheet filed prior to arresting him. He was directly arrested. With these two things, the council would now like to come towards
No, what are your arguments about Section 12?
Yes, Your Lordship. So they had highlighted that Section 12 does not talk about talks about due process, but there is nothing about due process. It merely talks about the powers of the authority, Your Lordship.
These are powers of appellate tribunal.
Yes, Your Lordship. They had
About the procedure to be conducted.
Yes, Your Lordship.
The powers of civil court,
Yes, Your Lordship.
which are detailed, those are mentioned.
Yes,
That
Your
is to facilitate, to give rights to the defendants.
Your Lordship, they merely talk about the basic powers of the civil court that have been animalized in all particular legislation. So anybody, be it under the RTI Act, everybody is given powers of the civil court. This is not one of the provisions which ensures like that safeguards are ensured. This is not a safeguarding provision. It does not talk about due process, but it specifically just mentions the various powers that.
Yes.
process in terms of arrest is absent, Your Lordship. That is the important part. That's what the council is trying to present. Due process in terms of arrest is absent in this particular section. Because the civil court cannot deliberate upon the very issue of arrest. Therefore, there is no due process. Now, moving ahead to the other provisions that the other arguments that the council seeks to revert. Firstly being that it was highlighted that hate speech over here, Your Lordship, what must be seen is the vagueness angle. So once again, the council would like to seek reliance upon the Shreya Singhal case, where it had stated that the vice of vagueness arises from expressions mentioned where they convey different meanings to different persons and depend upon subjective opinion. In this particular case, except for hate speech and except for hate speech content, nothing else has been defined in the statute, making it vague as per the standard given in Shreya Singhal. Also, this court in the case of State of MP versus Baldev had noted where the construction is not possible, the same would offend the very provisions of constitution. Secondly, Your Lordships, the council had noted that in this particular case, there is a particular criteria to be fulfilled, whereas under section 19, there is no particular criteria, and as compared to section 35, as reiterated before, there is a threefold criteria. There is reasonable complaint, credible information, reasonable suspicion. All these three criteria mentioned under BNS's lack mention over here, showcasing that the same have not been abided by. Once again, the next point that the council seeks to reiterate is the 180-day criteria. The 180-day detention criteria, even under Article 20, excuse me, Your Lordships, even under Article 22 of the Constitution, the 180-day criteria is not permitted. It also provides that only 90-day criteria for preventive detention is allowed. Only in exceptional cases can the legislature be permitted to make a law permitting overboard that. And even in my submissions, the council had constantly reiterated that the 7 years punishment and the 180-day detention do not go hand in hand, and it's not proportional to the existing statutes. Next, Your Lordship. Yes, Your Lordship. So the council had relied upon the case of Ram Manohar Lohia, citing this. But the Ram Manohar Lohia, with regard to restrictions, had also noted that the restrictions must be in the interest of public order, which have proximate reasonability. Over here, such provisions given by such provisions under this present act lack such sort of proximate reasonability to justify the test of constitutionality. If Your Lordships are satisfied with the rebuttal, the council would like to end this.
Their main argument
Yes, Your Lordship.
is that all the provisions are drafted in accordance with the aims and objects of the statute.
Yes, Your Lordship.
The aim to control and regulate
Yes, Your Lordship.
the contents of the in the social media. So with that aim, if these provisions are incorporated, what is the problem with that? You will have to regulate your conduct.
Your Lordship, firstly, the very council from side opposition had agreed that the powers under section 23, that is the power to remove difficulties to the central government, are, in a say, there is some sort of misprint over there, showcasing that they themselves are agreeing to an error in drafting, and they're seeking and they're not seeking to correct it, rather they are defending the same legislation over here, showcasing the intent of the government here. Secondly, Your Lordship, with regard to section 3, all the sections that the side petitioner has cited or has tried to present as to the test of constitutionality, all these sections fail the test of constitutionality because section 3, I'll very minutely summarize my arguments again, section 3 per se is abundantly vague because this meaning, except for the nationality and sovereignty part, the side council had constantly reiterated that the same is important for nationality and sovereignty purposes. But that is only clause 3, Your Lordship. Clause 1 and clause 2 of section 3 address any normal sort of incitement that may take place within the territory of India. And the problem with this is that without any clear wording, anyone who is an enemy of the government could be targeted in this sort of manner. Secondly, Your Lordship, even when coming to section 5 and 10, as Your Lordships had also addressed, when you take anyone's personal data, that too of an authority under the DPDP Act. A significant data fiduciary is an authority that finds mentioned within the DPDP Act. And that data fiduciary, Your Lordship, also gets that consent from that particular individual. Now, when you share such personal data, that is in violation of the norms of DPDP Act also, showcasing that this act in its very intent is malevolent.
All right.
If
Yes.
Your Lordships are satisfied, the council would like to rest it.
Yes.
It was an honor arguing before Your Lordships.
Yes.
Your Lordships, the respondents have pointed out regarding the Section 12 and due process of law. Your Lordship, my submission was that the online regulatory authority under Section 12 has the power of civil court, and therefore they are bound to follow the due process of law. That was my submission, Your Lordships, regarding online regulatory authority. Further, Your Lordships, the respondents have relied on the case of Shreya Singhal versus Union of India. That, Your Lordship, the Council humbly submits that in Shreya Singhal versus Union of India, Section 66A of the Information Technology Act was struck down because it criminalized discussion and advocacy, used vague expressions, and had no proximate connection to public order. The present provision is clearly distinguishable because it targets specific harmful conduct. It has a direct nexus with grounds under Article 19 Clause 2, such as public order and security of the state. Further, it does not criminalize mere criticism, discussion, or advocacy, as Section 4 of the Online Hate Speech Prevention Act protects these speeches in good faith. Your Lordship, Section 4 provides that no legal proceedings shall be instituted against a user under Section 3 for an action done in good faith during the course of engagement in any artistic or creative performance or other form of expression, to the extent that such performance or expression does not advocate hatred or online hate speech, or any academic or scientific inquiry, or fair and accurate reporting or commentary or critique in the greater public interest. Further, Your Lordships, the Council of for the petitioners have referred to the BNSS. Your Lordship, the Council humbly submits that the Online Hate Speech Prevention Act is not subject to BNSS. It is a special statute, and under Section 22 of the Act has overriding effect, and thus it doesn't need to be in compliance with BNSS. The Council is done with the rebuttals.
Yes.
Much obliged.
You have any other explanation or reply to the query about discrepancy in Section 14, apart from that power to remove difficulties clause?
Certainly not, Your Lordship.
All right.
Much obliged.
Thank you to all the participants. Your dedication and hard work was truly inspiring, and I think I would be speaking on everyone's behalf when I say that we can be rest assured that the future of legal field is in the safe hands. I would humbly request our honorable judges to kindly share their remarks with us.
Respected principal sir, faculty members and participants, I must thank to the organizers for calling me here and giving opportunity. All the participants have shown their hard work, sincerity, and all the best to them. But this hard work, sincerity will carry forward to in their life, and in future they can or in arguments, specifically on arguments, they will be benefited. Winner, runner is all the way two sides of the coin that will go on, but participation is very appreciating. I must appreciate all the persons. We know the restriction, limited facts, limited, somewhere you will have to adjust it, but you have given good answers to the queries. Response is very good. Thank you very much. All the best.
Respected Jawarkar Madam, respected faculty members and dear students, it was indeed a pleasure and a very enjoyable occasion for both of us, I must say, on behalf of my senior sister, because we found that the participants are very well prepared. The moot proposition was also very interesting. In other moot courts, I have seen moot propositions running into more than 50 pages. But here, this was very short and very interesting issues were raised. Both the sides presented their cases very well. The queries which were made were not to just take to you to some deadlock, but just to analyze, to see how you respond in such situations. So in whatever moot proposition is given, whatever area of research which you can do, if your responses were based on your best possible efforts, then the attempt was to just see whether you can respond in all those parameters. And I must congratulate both the teams. One of you will be winning team, other will be runner-up. But personally, I believe each one of you have performed very well. And I am sure in this process of preparing your case and presenting here at the podium, you have learned so many things. These things which are of invaluable, you cannot value these efforts. And I am sure whenever after finishing your law course, you will go and argue matters before the courts. Actually, the mental process through which now you have gone, these experiences will be of lot of help. I must share with you one word of caution. When you argue your matters before courts, somebody's life, somebody's property, somebody's personal liberty is at stake. So you have to be more cautious when you argue. We have seen some senior judges have expressed their views that many times they have seen some junior lawyers arguing cases as if they are arguing in moot courts. You have to realize after you become lawyers that your arguments are going to decide fate of somebody. So that sense of responsibility should be kept in mind whenever you will argue your matters. Now you are at this stage when you are arguing a moot court competition. Your performances are expected to be just to reply to the queries. So this word of caution that whenever you argue your cases before courts, these experience may be of help, but at the same time you should keep in those times the fact that somebody's decisions about somebody's rights, somebody's property, somebody's personal liberty is going to be affected. So I hope that this experience will enrich you, will teach you many other things. Those who have performed and even those who have just witnessed the activities must have learned many things. I wish all of you best wishes for your career and congratulations for participating and going through this wonderful mental process. Thank you.
Thank you so much, the Honorable Justices. Now it's time to say thank you to everyone who made the discussion. I would like to call the student coordinator of the moot court competition to please, Ishita Dubey, to please give the vote of thanks.
Thank you so much. Good afternoon, everyone. I, Ishita Dubey, the coordinator of Moot Court, am truly honored and privileged to stand before you to deliver the vote of thanks for the 23rd Justa Causa's National Moot Court competition. Firstly and foremost, I would like to extend a heartfelt gratitude to the Honorable Justice Srimati Mukulika Javalkar Madam and Justice Shri Prafull Kubalkar Sir. Thank you so much, sir. Thank you so much, Madam. Your insightful judgments and discerning legal minds have undoubtedly elevated the standards of this competition. Thank you so much. Further, I would like to say a special thank you to our Honorable Director Ravi Shankar Moot Sir, whose leadership and unwavering support have been the backbone of this event. to Dr. Praveena Khobragade ma'am and Dr. Adra Deshpande ma'am, whose guidance and encouragement have inspired both the participants and organizing teams alike. Further, I would also like to convey my deepest appreciation to our esteemed faculty members, Mrs. Vidya Nayak ma'am, Mrs. Darshana Malani ma'am and Ms. Gargi Chaube ma'am, for their continued mentorship and support, which have played a significant role in shaping the event and making it successful. To all the talented participants over here, your passion, dedication and hard work have been truly aspiring. Moot court is much about handling questions, but it is also about making the argument and putting your perspectives. And today, you may not take a trophy, but you will definitely take a perspective, a discipline and a better understanding of law that is in practice. Finally, I would like to thank all the volunteers who have contributed behind the scene. Your tireless efforts ensured that everything ran smoothly. Your dedication reminds us that teamwork and dedication are the true keys of success. Thank you all once again for being part of this wonderful journey. Let's continue to challenge, inspire and advocate for a better tomorrow. Thank you so much.